Ladies and gentlemen, during today's conference we have already discussed many issues, interesting issues related to the broadly understood functioning and organization of online platforms, social media, and the connection of this issue with the democratic standard of freedom of expression one's view. We have seen the results of our research group devoted to the issue of the place, influence, and effects of social media on our lives. As part of our research group, as already mentioned, researchers analyze in details the issue of typology, restrictions, source, and limits of the impact of social media on the lives of citizens, as well as their influence and role on the functioning of the state structures. We have analyzed both the shortcomings and the benefits of social media. I have no doubts that all the analyses deserve our special attention because all of them together give extremely interesting results and allow for an important conclusion about the need to control this not yet fully explored area of broadly understood social media. Esteemed guests, let me now present you with my own observation and research analysis which I made as part of the Central European Professors Network project. Therefore, the subject of my speech will be the issue of determining the legal responsibility for the negative impact of social media understood as a tool for creating, disseminating, using, and often imposing the interpretation of specific information which, depending on the content, context, and effect, may colloquially be referred to as fake news. Currently, I limit my consideration only to the area of my specialization, broadly understood criminal law in the system of Polish law. Ladies and gentlemen, the research assumption in my work were very simple. In my study, I put together three areas which are: firstly, the area of digital platforms, social media understood as tools for creating, propagating, or interpreting specific, in our case, untrue information referred to as fake news. Secondly, the area of substantive criminal law, which consists of a coherent system of sanction and principles of incurring criminal liability. In the Polish legal system, in this case, the most important legal act is the penal code. Thirdly, the area of procedural criminal law, or simply the criminal process, criminal procedure, which perform the role of the executor of the aforementioned substantive criminal law. In the Polish science of criminal law, it is emphasized that criminal procedure law plays an auxiliary role in relation to substantive criminal law. In the Polish legal system, in this case, the most important legal act is the Code of Criminal Procedure. It is at the interface between their complex issues that the answers to the following questions should be sought. Firstly, if we define legal liability as negative consequence defined by law, for example, the application of sanction, towards a specific entity related to the occurrence of the negative state of affairs dependent on this entity, that it is legitimate to ask the question, what kind of liability should be ascribed in our case in the functioning of fake news phenomena. Secondly, when switching to criminal law, it is reasonable for us to ask question on how and whether criminal law should be involved in the protection against the fake news or to combat fake news. In other words, should the codes of democratic and modern states define the crime of fake news? And to be able to answer these questions, we first need to feel and understand the nature and purpose of the broadly understood criminal law system. Dear guest, in Poland the structure of the criminal law system is generally simple. The system is interconnected and contemporary. It consists of their inseparable basic segments. Segment number 1, substantive criminal law. Segment number 2, formal criminal law. Segment number 3, executive criminal law. Referring briefly to each of them, I emphasize that substantive criminal law in Poland is primarily the criminal code, and it mainly regulates the basis assumption of criminal liability, a description of a prohibited act, a catalogue of crimes, or catalogue of penalties for these crimes. Formal criminal law, also known as procedural criminal law or simply a procedure or criminal procedure, is a code of criminal procedure which contains the rules of conducting a criminal dispute, namely the rules of finalizing the scope of criminal liability for the committed crime. And the third segment, executive penal law, is a set of legal norms used to enforce penalties or other decision made therein. These areas compose the criminal law system in Poland, and now they will be the basis for the search for the main subject of research, which is the possibility or perhaps the need to establish the rules of incurring criminal liability for the fake news. Nevertheless, as we know, after all, criminal liability is not the only legal responsibility. In the foundations, the basis of every legal system, there is also civil liability or administrative liability, and then we even have the constitutional liability. On the other hand, criminal liability, I think we will all agree here, is the most controversial legal liability, because it, like no other, allows in the majesty of the law to interfere most deeply with the status of the free individual, the status of a citizen rights. It is so because, generally speaking, criminal law is a public law, where the above-mentioned interference with our rights and freedom is the most visible. If we already allow this kind of criminal interference, it must be predictable and socially justified. In Poland, criminal liability is the responsibility of the perpetrator of a socially dangerous act prohibited under penalty by the law in force at the time of its commission. At the same time, the basis of responsibility cannot be the thoughts, views of a person or his physical and mental properties. Criminal liability in Poland is generally born on the basis of the aforementioned penal code only by sane natural person who have committed a prohibited act after the age of 17. It is not a crime, a prohibited act whose social harm is negligible. The perpetrator of the prohibited act does not commit a crime if he cannot be guilty at the time of the act. Therefore, in order to design a new institution, a phenomenon, or another legal entity in the area of criminal law, we should take into account the specify and profile purpose and effect of this area. Therefore, in order to integrate criminal liability for fake news into the legal system well and responsibly, its most important features should be taken into account in great detail, and these are: firstly, the inequality of entities, because on the one hand we have the injured and the accused as the witness parties in criminal proceedings, and on the other hand we have the state with an enormous jus puniendi, in example, the law of the punishment. Secondly, repression, which is an inherent feature of criminal law in the area of criminal law, which is necessary to ensure its effectiveness. Thirdly, the arbitrariness of certain procedural decision. Fourth, spectacular conduct of criminal proceedings, its media coverage, social interests which in criminal proceeding regarding a possible crime of fake news may be a very important element. Five, and in my opinion the most important feature, in example, the primacy of the public interest over the private interest in criminal law and proceedings. According one of the rulings of the Polish Constitutional Tribunal, criminal law is essential function a public law. Therefore, it protects both the interests of the community and the individual interests of the members, the respect of which creates the conditions for the harmonious functioning of social life. It is the public prosecutor who decided whether there are grounds for initiating proceedings for the commission of an offences prosecuted by public prosecution and therefore constituting a branch of the public interest both when the injured person is an individual or a group. Fifth, the private interest, for example, that of the aggrieved party in criminal proceedings in an auxiliary element in the operation of criminal law as a public law. So, in order for a certain model of a phenomenon to be considered a crime, it should first directly or indirectly infringe the public interest. In most cases, incurring criminal liability is needed related to the violation of the public interest. With this assumption, I admit that there is no strictly fake news crime in the Polish Penal Code. However, in my opinion, now it is possible to try to initiate criminal liability for fake news on the basis of some of the currently applicable provisions of the aforementioned Penal Code. For example, therefore, if false information, fake news of course, causes constant harassment of a person, discrediting them, undermining their reputation, etc., it is then that the offense of persistent harassment in foreseen. This is Article 119a of the Polish Penal Code. In the purpose of false information is to present, for example, a person, institution, etc., in a negative light, then it is a crime of defamation. It is 211 of the Polish Penal Code. A very similar regulation can be found in Art Provision 216 of the Polish Penal Code regulating the offense of insult, where it is inter alia that whoever insult another person by means of mass communication is subject to a fine, the penalty of restriction of liberty, or the penalty of deprivation of liberty for up to 1 year. When a fraud would take place on the basis of disinformation, the provision of Art 286 of the Penal Code, namely the offense of fraud. It is also possible to imagine a situation where false information constitutes the basis for an action against the security of the state. It's very serious. Here the Penal Code provides in Article 142 responsibility for intelligence disinformation. Another example where the creation of or dissemination of fake news may be part of the structure of a specific crime in another provision of the Penal Code, according to which whether publicly insult a group of the population or a particular person because of their national, ethnic, racial, religious affiliation, or because of their lack of religion, or for such reason violates the physical integrity of another person, shall be subject to the penalty of deprivation of liberty for up to 3 years. Therefore, looking at these examples of only indirect imputation of criminal liability in the Polish legal system for fake news, I believe that criminal law should deal with the most important manifestation of disinformation, such as fake news or disinformation that threatens the security of the states. In this case, as a result of fake news, the public interest of the highest degree is violated because it is about the security of the state and therefore all citizens. Disinformation, fake news or minor importance should be dealt with in another branch of law, such as civil law, for example. Therefore, in order to organize the matter studied by me in my research, I proposed the scale of legal liability for the fake news. It is based on the division of fake news according the degree of violation of the public interest. Here the criteria for assessing the fake news, it is content, degree of lies, the degree of violation of the truth, and finally the effect are important, which will decide in the area of which law whether civil or administrative or ultimately criminal prosecution of the entity responsible for fake news. Hence, let me propose the following classification of the fake news, where the criterion is the type and effect of dissemination. The first group includes fake news of the first degree, which will constitute the highest type of lie, false information, its content and substantive load having the highest impact. It will be investigated here whom and what such fake news concerns with whether the creation and publication of fake news threatens the highest values protected by law, such as social peace, health and life of citizen. An example here will be change manipulation, falsification on indisputable historical facts or presenting the course of a certain event carrying a huge social load in a manipulated manner, falsified in the direction of fueling emotion, ridiculing or discrediting the most important facts, or leading people in the country, or creating and disseminating such information which will threaten social security. The second group will be second degree fake news, which are activities of much lesser effect, affecting more the reputation of a person, affect violation only the private area of the subject or the fact. We find no major impact here on the public sphere, but the element that is the main subject of fake news experiences discomfort. The approach here is too satirical, too distorted, that in principle each of the logical thinking people will indicate a significant transgression of, for example, aesthetic or moral norms. Therefore, the best area of legal responsibility here is the area of civil law. The third group is fake news of the third degree. They are the use of manipulated content, false information in the area of their professional group. This is a much smaller area than previously indicated. An important factor here is the professional or social group with which functions according to generally established principles of the so-called professional deontology. Then disciplinary professional liability comes into play. In example, this type of responsibility left for a specific group of entities. The last group will be fourth degree fake news, which are light behavior, essentially sanctionless, ineffective, producing and propagating fake news on the basis of satire, fun, etc., without much effect for its production, distribution or use. There is no sanction of any kind for this type of fake news. Ladies and gentlemen, times for conclusion. The pretended analysis showed that the Polish criminal law system does not strictly provide for criminal liability for the crime of fake news. Criminal law, however, is a specific law in the legal system of each state. Therefore, criminal law should deal with the most important fake news, for instance, disinformation that threatens the highest values such as state security. This information of minor importance should be addressed in other branches of law, such as civil law, because it has been known for centuries that the criminal law, as the most repressive law, should always be used as a last resort, as a regulation of the ultima ratio. Dear friends, that's all. Thank you.